recover, which is very sad. And I also remember a report which was made by not so long ago, which is showing that quite some data will also be leaving Zambia, and that we are perhaps recovering a very small percentage. It's a bit, of course, it's always anecdotal because they're a bit difficult to do a scientific, very scientific, proven research on how much is getting lost and a percentage relative to the percentage of what is being recovered. So the search for an effective way of having those assets recovered and communicating across jurisdictions has always been a process. Now, the networks came in to improve the success of tracing and recovery efforts, often which are externalized. And cooperation, and I like the way that my previous speaker has ended, cooperation and collaboration internationally becomes very key when it comes to transnational financial investigations, as well as recovery and return of those assets. Now, the cooperation that is formal, that is called the mutual assistance, is problematic, and it has always been said this is problematic, but there doesn't appear to be having a very clear solution to it. We have differences in legal traditions. You just need to cross over even to the country which is next, and you realize things are slightly different. You could be having common law all of you, but the traditions, the kind of practices that there are may be quite different. There are differences in procedures, there are differences in languages, and language is not an easy thing that one may assume, or a difference in language, and it can be overcome very easily. It's not. Indeed, I remember one time that we went to Japan, and I almost ran into a problem when we were doing mutual assistance, and the issue was language. They could speak Japanese very well. They could speak, English very well, and we were always communicating in English, and I thought that we are going to get into English. But when it came to the interview witnesses, they insisted that I get an interpreter. And I told them I was speaking English very well. And I thought even the witness was coming is after speaking English. In fact, he was based in the US. But they insisted they have to get an interpreter in Japanese. And I couldn't get it. It was high season of tourism, and we couldn't get an interpreter. And it ended up being very much, in fact, they reported back on the road that they are becoming uncooperative, something that they didn't know it had been as serious now. So language can also be a big challenge. And there are varied capacities. Actually, when you cross over a jurisdiction and then you realize that the capacities that you are assuming because you have, they actually do not have those kind of capacities. And there are protocols to be observed. It has to be writing, it has to go through the central authority. Indeed, just the channels of communication of mutual assistance become a big problem. Currently, I think in Zambia, in some places, we are having mutual assistance requests which are going to a country, but we are not even able to trace where they are right now. They are told they are at the central authority, but usually have nothing much to do else because nothing is being done there. So all this will have to be observed when it comes to mutual assistance, and therefore the practitioners themselves who are feeling the weight of all this and the pain are the ones who started talking about we need to do something. We are the ones who are suffering. We are the ones who require these assets returned. And they started forming these networks. And essentially, the main driver of the networks is to overcome formalities. But there is still the question of receiving evidence, formally, and receiving evidence that is admissible. I am aware that, and have been reminded a few times that in Zambia it is possible to present in court evidence which is not so legally obtained. But again, that may as well be in Zambia. But what about when you are going to get evidence from another jurisdiction? Because they are going to give you the information that you require, and perhaps even the evidence that you require back. It will come with a conditionality that you cannot use it as evidence unless it is formally released. Now, that presents a challenge. And you still find that we still have to go back and go back to the aspect of mutual assistance. And when you go to the mutual assistance, then again you find the complementarity of networks, because the evidence that you're supposed to put in the mutual assistance request, for it to be satisfactory, to satisfy the necessary suspicions and all that you are requiring and you are requesting, you need to get it informally. So that's the place and space of networks. So this is the value proposition, what I call value proposition for networks. They are forums for trust building, and trust me, trust is the main thing. Of course, when it comes to investigations and when you are making inquiries, there is always the fear that the information that you have must be treated in a confidential way. You have fears, there are fears that they are real, that there might be a leakage if you share the others. Of course, you see officers going around with a red file marked confidential, and they even want to keep it away from their own colleagues. What about if you have to communicate outside, and you no longer have control of that information? So these networks are critical when it comes to building trust. Of course, the next one that they bring together law enforcement agencies to advance this one, operations, is easier to understand. And they provide channel for exchange of information. Yes, they do. Indeed, there are some networks which are becoming informal, and I'm glad that you ended up in the group E, and they are formalizing those channels of communication between the practitioners. Now, influence, capacity building training, that is obvious. I think Alisa has been doing a lot in capacity building here in South Africa. Do they have legal basis? We are calling them informal networks. They are informal, and the informality is very important. It's the key driver. But if they are in a legal basis for that, yes, there is. Indeed, there was realization from the very beginning, at the point of negotiation of the contract, that can also be said to be a basis for these networks. But the outcome, Article 27 even was far. Of course, now it was dealing with organized crime, and it appeared that more evidence when it was mainly driven by the aspect of drugs, that this informal operation is very important. To enhance, so it has that particular article that speaks direct to the aspect of networks, and all those bullets that are listed there are actually within that article. Next. Now, I think that I'll leave that slide, and because it's going to be supplied, you can get back to that link that is there, and you see the map. There is that map which is when you click on the link, then you can see those countries who have actually returned assets. And sadly, it's finally in Africa. And that is where we intend to be. Because even assets have been standardized in between African countries. Let us look at the networks themselves, which are, there are some global networks. And one of them is what they call GFAR. The GFAR, like the Forum for Asset Recovery, Global Forum for Asset Recovery, was one of the, not very early, because this emanated from the 2016 Anti-Corruption Summit, which was held in London, and there were a great number of resolutions, and the law enforcement pillar is the one that ended up giving rise to they came up with what they call GFA action series. And the GFA action series is intended, and this is what they seek to achieve, to bring together law enforcement agencies who are seeking assistance from other countries and the requesting countries. They sit together and discuss case-based operational issues and try to solve those issues across the team. And I'm glad to say that we have supported Zambia together with the UNODC in Zambia becoming the second focus country under the GFA action series. And we have had quite a number of meetings in Vienna, in Atlanta, and we are looking forward to having another session in Beijing. And I tell you that it has been extremely useful advancing actual cases. Next slide, please. The GROW network, it has already been addressed, is one of the most important networks now with very practical issues that are being addressed. And the GROW becomes very useful because mainly it comprises of the agencies themselves. And it is an association of the agencies, if I may call it so. And I recall that it started with what was called the RIAD initiative towards the creation of a global operational network of anti-corruption law enforcement authorities, which was around 2020, and it ended up being launched in, I think, 2021. This global network is a network for like-minded associations and sitting together and seeking to advance issues that are operational becomes a little easy. And there is the encouragement of face-to-face trust-building meetings. But again, GROW is becoming a little more innovative in the establishment of what they are calling one-stop hubs, practitioners forum. I'm not very sure that it has been operationalized already, but that hub is supposed to have resources, or the laws of the other countries and what they're doing. We have resources which are posted in that hub, and also over and above, they are seeking to have a secure communication system between law enforcement authorities. And I think we can't wait for that to go online. Next slide, please. Of course, there is ECMO group, which is a very popular one, a network of FIUs. And I think that the GROW is trying to establish this channel of communication that is equal to the GROW. And of course, they talk about trust. Trust is very key. And the ECMO group really takes that very seriously. We are dealing with the level, at the level of communication, at the level of protection, and therefore trust becomes very important. There is serious vetting, and you have to qualify to be a member of the ECMO group. Next slide, please. We also do have the regional networks. The regional networks, I'm talking about the region of Africa, which would be useful to all of us. And one of the most important, of course, and the most relevant to the prosecutors is the African Prosecution Association, APA. And I believe Zambia is a member. And they still seek to do the same thing, establish a forum for information exchange and training. And, coordination of judicial processes among prosecutors. There is a West African one, and there is the East African Prosecutors Association. I was not able to find one for the East, for this Northern Africa. And that would be my favorite. If it is not there, then it really needs to be established. Next slide, please. The area anti-corruption authorities, and of course, Angelica is a little more generous. She's going to be 5 minutes. I have 2 minutes. Of course, there is the African Umbrella Association of anti-corruption authorities, the HACA. There's the East African one, which is a little older than even HACA. And of course, there is the Association of Parliamentarians Network Against Corruption. And APNA also extends it to the civil society and the private sector in terms of coordination and cooperation. Next slide, please. This could even be the last. Yes, thank you so much.
It is our duty to ensure that the international speakers and participants learn a few words in our local languages. So in Denmark, we say, so we'll not add anything to Julia's representation. I'll just go ahead and call upon Mr. Alan to give us the internal perspective of mutual legal assistance. Mr. Alan, sir.
Good afternoon, House. Good afternoon. May I simply write of the protocol greatly accepted. My full names are Alan Okalo, Senior Assistant Commissioner of Police, in charge of Crime 2. Quickly run through my presentation. I think most of the things have already been said by the previous speakers. And for that reason, I will not repeat most of the things that she has already touched. As earlier said, I will be looking at the mutual legal assistance in criminal matters in relation to international police. Mutual legal assistance is a crucial aspect of international cooperation in criminal justice. It allows countries to request and provide assistance to one another in criminal investigation and prosecution. Mutual legal assistance is a process by which countries request and provide help in legal matters, particularly in criminal investigation and prosecution. Essential to tracking transnational crime, which include, among others, terrorism, human trafficking, and money laundering. The legal framework for MLA in Zambia in criminal matters is the Mutual Legal Assistance in Criminal Matters Act, 1993. Also, in that act, you find the Extradition Act, the Penal Code, Chapter 7 of the laws of Zambia. There are also international conventions that we can invoke to enforce the mutual legal assistance, among which I think UN Convention Against Transnational Organized Crime, African Union Convention on Preventing and Combating Corruption, the SADC Protocol on Mutual Legal Assistance. Importance of mutual legal assistance. Mutual legal assistance is essential for combating transnational crime and ensuring that criminals are held accountable for their actions. It helps to bridge jurisdiction gaps and also overcome obstacles in cross-border investigations. Essential to this is sharing of information among investigating wings, enforcement of judgment, also protection of victims. On sharing information, countries can share crucial evidence, witness statements, and other information to assist in investigation and prosecution. Enforcement of judgments, mutual legal assistance enables countries to enforce judgment and arrest orders issued by foreign courts. Protection of victims. MLA can facilitate the protection of victims in crime, including the return of stolen property and provisions of suspect support services. Procedures for requesting mutual legal assistance. Countries typically have formal procedures for requesting an MLA. These procedures can often involve written and mutual requests specifying the nature of the assistance sought and supporting evidence. There can be initial requests. Number one, the requesting country submits a formal written request to the requested country, review and approval. As a second stage, the requested country reviews the request and decides whether to grant it or not. Execution of request. Number three, if the request is approved, the requested country takes the necessary steps to provide assistance. Types of assistance covered under mutual legal assistance. Mutual legal assistance encompasses a wide range of assistance, including the taking of evidence, the execution of search warrants, the arrest, extradition of suspects, and provision of legal documents. Evidence gathering. Number one, mutual legal assistance can facilitate the gathering of evidence such as witnesses, statements, documents, and physical objects. Number two, mutual services of legal documents. Service of legal documents. MLA can be used to save legal documents such as summons, subpoenas, warrants, an individual located in other countries. Thank you very much. Extraditions. MLA can facilitate extraditions of suspects from one country to another to face criminal charges. Freezing of assets. MLA can enable countries to freeze assets that are suspected to be linked to criminal activities. Challenges in obtaining mutual legal assistance. One, I think it has been explicitly explained, different legal systems, language barriers, sovereignty concerns. These are some of the issues that hinder the execution of mutual legal assistance. Role of international conventions and treaties. International conventions and treaties such as the United Nations Convention Against Transnational Organized Crime establish frameworks for MLA and provide guidance on procedures and legal standards. Conventions, United Nations Convention Against Transnational Organized Crime. The purpose of this, which I know you being many people know, the purpose to promote cooperation among states in combating transnational organized crime. European Convention on Mutual Assistance in Criminal Matters to facilitate mutual assistance between member states of the Council of Europe in criminal matters, and so on. Procedures of requesting MLA. Identify the need, determine the specific assistance required, such as evidence collection or witness testimony. Two, draft a request, prepare a formal request document detailing the assistance needed, including the legal basis and the urgency of the request. Transmission. Send the request through the diplomatic channels or via the central authority of the requesting and requested countries. I want to submit to the House that when this is prepared, which is the sole responsibility of the Ministry of Justice, example, copies are given to the police, which they send them through the I-247 system, the Interpol system, which is also conveyed to the requested country. Assistance provided includes locating, as I think we've dealt with this, communication channel, this net authority from state shall communicate directly with one another. Such communication may also be affected through can be effected through the diplomatic channels or through the Interpol criminal system that we have. Content of skip and grounds for refusal. The request relates to a political offense or often of political character. 2, the request relates to an offense under military law, which would not be an offense under ordinary criminal law. 3, the execution of the request would impair its sovereignty, security, public order, public interest, or prejudice the safety of any person. Last, that the request is not made in conformity. For example, if it doesn't conform with the certain protocols, such a request may be declined. We have had as police a few success stories. I think you can see the name of countries, extradition on them from countries, and please note it, and offenses that they committed. Conclusion and key takeaways. An MLA is essential for combating transnational crime and ensuring the criminals are held accountable. It requires a strong international cooperation, clear procedures, and a commitment to upholding the rule of law. Cooperation is integral, fairness, legality, and efficiency. Role of Interpol provides communication channel through secure global police communication system. 1, 2, supports Zambian authority in tracking suspects and shared operations. Coordinates international investigation assistance. The mutual legal assistance process is vital for Zambia's role in combating transnational crime. Thank you very much.
Thank you very much. That's Interpol's perspective. We will now call upon Ms. Namwa to come and give us the perspective of mutual legal assistance from the Ministry of Justice perspective. Ms. Namwa. Good afternoon. Good afternoon, everyone. Hello, good afternoon, everyone. Thank you. Well, before I get to introduce myself, the beauty of being the last speaker is that everything else has been said, so my presentation will actually be very short. My name is Cynthia Pelachineko. I'm from the Ministry of Justice, Attorney General's Chambers, and basically my presentation, despite everything else being said, will focus on the challenges encountered by national authorities in facilitating mutual legal assistance requests, best practice recommendations for facilitating international cooperation in mutual legal assistance in criminal matters, and the last issue will be on the importance of networking in facilitating in international cooperation in criminal matters. Well, I'll start by defining what mutual legal assistance is. My colleagues touched on it. Basically, M&A is any assistance given by the requested state in respect of investigations, prosecutions, or proceedings in the requested state
in a criminal matter, irrespective of whether the assistance is sought or is to be provided by a court or some other competent authority. The principle of mutual legal assistance in criminal matters, also referred to as judicial assistance, and cooperation centers around two obligations accepted by many states, namely the obligation either to prosecute presumed criminals themselves or to extradite the accused to the state concerned by the crime committed or to the state that has an interest in pursuing the accused. I won't dwell on the extradition bills. I will only dwell on the mutual legal assistance. My colleague touched on the issue of the national legal framework relating to mutual legal assistance. Primarily, we have the Mutual Legal Assistance in Criminal Matters Act, Chapter 98 of the Laws of Zambia, which basically provides for the implementation of treaties for mutual legal assistance in criminal matters. I will just say that Zambia has a dualist system, and the status of international treaties is that national legislative, I beg your pardon, Zambia has a dualist system, and the status of international treaties in the national legislative framework is that international treaties are only enforceable if they are ratified or domesticated so that they become part of our national law. I wish to also state that Section 7 of our Act states that where there is no treaty between Zambia and another state, the minister responsible for home affairs may, with the agreement of the minister, that is the Minister of Justice, enter into administrative arrangements with the other state providing for legal assistance. I won't get into our national laws on the basis of which cooperation can be sought. We touched on it, the Constitution of Zambia. I can quickly run through it. The Constitution of Zambia, the Mutual Legal Assistance Act, the Extradition Act, the Transfer of Convicted Persons Act, the Forfeiture of Proceeds of Crimes Act, the Anti-Human Trafficking Act, the Penal Code, as well as the CPC. Well, I think this is an important issue to address, basically on which entity should submit the request. Well, in Zambia, it is the Attorney General. The Act designates the Attorney General as the competent authority. Basically, the entities responsible are the Ministry of Home Affairs. And when I say Ministry of Home Affairs and Internal Security, we have entities like the Anti-Corruption Commission, we have the Drug Enforcement Commission. We collaborate with them as Ministry of Justice, so these are the entities responsible. Last but not least, which entity should the requesting state address the request here in Zambia? And for us, it is the Attorney General, according to Section 10 of the MLA Act. I won't delve into the procedures applicable to mutual legal assistance in criminal matters, which my colleague just spoke about. Also the issues of production of documents, procedures, what happens once a request for MLA has been successfully received. My colleague touched on that one. So getting straight into the challenges, which most common obstacles are encountered by national authorities in facilitating MLA requests. One, insufficient information due to failure to submit required supporting documents, differences in legal regimes, for instance, between states in their domestic legislation and practice in executing requests, bureaucracy in the processes, which leads to a very long turnaround time. More often than not, we always get complaints from member states as to why maybe we would have delayed in actioning certain requests. But normally, those are the challenges that we face even as Attorney General's chambers. So, what can we do? I'll look at some best practice recommendations for facilitating international cooperation and mutual legal assistance in criminal matters. I'd like to begin by stating that one of the best practice recommendations would be that we could strengthen the effectiveness of national or central authorities. And what I mean is that it is important to have staff who are legally trained and who have developed institutional expertise demonstrative arrangement can be made. The second one would be enhancing the effectiveness of mutual legal assistance, treaties and legislation. States should develop broad mutual legal assistance laws and treaties in order to create such legal basis. The third would be ensuring awareness of national legal requirements and best practices for domestic and foreign officials involved in the mutual legal assistance process. That is, the procedures must be known so that we quicken actually either the investigation process or even the prosecution. The fourth one would be expediting cooperation through the use of alternatives to formal mutual legal assistance requests. That is relying on information or intelligence to be sent through police to police, which is faster than more formal routes than the formal route of mutual legal assistance, just as my colleague indicated, overcoming formalities. The last one will be maximizing effectiveness through direct personal contact with authorities in other states. That is basically contact between members of the central authorities, prosecutors, and investigators from the requesting and requested states, which will be very important at every stage in the mutual legal assistance process. The last part of my presentation basically is focusing on the importance of networking in facilitating international cooperation in criminal matters. Like I earlier stated, networks play a crucial role in facilitating international cooperation in criminal matters, in this case particularly in the context of mutual legal assistance. The networks provide a platform for law enforcement agencies, judicial authorities, and other relevant stakeholders, including prosecutors, to communicate and collaborate on cross-border criminal investigations and prosecutions. I'd like to state that one of the key functions of these networks is to streamline the process of requesting and providing mutual legal assistance between states, which involve facilitating the exchange of information, evidence, and other forms of support necessary for investigating and prosecuting transnational crimes. Networks also help to ensure that requests for assistance are properly formatted. Normally we have a challenge with that, and submitted to appropriate authorities in a timely manner, thereby enhancing the efficiency and effectiveness of international cooperation in criminal matters. Networks also play a critical role in promoting capacity building and knowledge sharing among states, thereby fostering great understanding and cooperation between states. Networks also contribute to the development of a well-coordinated and effective response to international criminal activity. Overall, and I'll conclude by this point, networks serve as an essential mechanism for promoting international cooperation in criminal matters by facilitating communication, networks play a crucial role in combating transnational crime and upholding the rule of law on a global scale. Ladies and gentlemen, so basically my presentation focused on the challenges, the best practices in terms of recommendations, as well as the importance of networking in facilitating international cooperation. All these border on having an effective way of dealing with mutual legal assistance requests. Thank you so much.
Wow, these three experts just simplified mutual legal assistance and made it sound so easy. Thank you very much. Let's give them another round of applause. Thank you so much. Now, they have emphasized on networks. They will be here throughout the conference. They are Zambian. Yes, Jonas with a lot to do with Zambian. So if you need to engage them, please get their contacts. Every time you're doing a mutual legal assistance, you need assistance. Engage one of them and they'll be able to guide you on how to do this. So we can't ask all the questions we need to ask them because we won't do them justice. So what I would urge you is to get their contacts, get their emails, find out where they're found, but I'll just ask for one burning question, if there is any. One burning question. Okay, I do not see any burning questions, but oh, there's one at the back very quickly. I would ask if that mic is on, would you please come to that table where there are the fixed mics?
Good evening.
Good evening.
Good evening, my name is Yoro Mbazi, and my question really is very, I just want to know what proactive measures we are taking as a nation, and of course as a region, on asset management and cost of crime insofar as cryptocurrencies are concerned, knowing that our target groups have people moving from real estate or other process of crime into crypto, and any ardent follower of cyber-related activities. I would want to know whether we have put any legal framework in place to deal with crypto. Yeah, I think.
Any of the three speakers will take the question? Mr. Mike,
Not that I really have competences in answering that question, really, but I think cryptocurrencies is not so much of management. I think the very fundamental question is being able to, seize the cryptos. I think that is even more critical because I think our first stage, I think management will not be such a huge, it's not, in my understanding, my little understanding of it, it will not be a very complex asset for purposes of management. The complexity arises before stage, and are you able to get those warrants, get those get the cryptos themselves and be able to freeze them? I think that would be the first issue. But in terms of whether anything is being done, I'm getting the appropriate legal framework for that, and I will be able to answer. But I was also wondering whether there is anything so much of law that could be missing in getting the cryptos, other than so much of the skills.
Mr. Allen, do you want to weigh in?
I don't know why we are struggling. With this, we have the DPP himself, which should be able to take up that. I wouldn't want to commit myself with anything that is being done. These are being drafting legal framework to care cryptocurrencies. The DPP here should be able to handle this.
I'm not sure if the DPP anyway. The Minister of Justice, before the DPP comes in, the Minister of Justice will draft the law, but you want to weigh in before the DPP is in answer to say something.
Well, not aware of any such legislation that is being drafted, but I stand to be guided by the
Indeed, you see, I think earlier in the day we had someone alluded to the fact that, you see, these criminals are quite swift, they're ahead of us, and we must make sure that that should not be the case. Okay? So we must respond. I think that we must find answers. So the question that has been asked is, it opens our minds to consider what responses do we have. There's a case that we're currently dealing with, and partly it involved crypto. And I recall that in that case, without going into specifics, we were able to go into mutual assistance, and eventually we somehow settled that case. It did not go this logical conclusion to court, but we managed to settle it. Obviously, we could see a gap even in the investigation because of that crypto aspect. So this is a challenge I think that we need to address. Clearly, we do not have legislation that answers to the challenge that has been posed. So it's, I think, food for thought. We must find solutions. Thank you.
Thank you very much. But we can have a discussion over tea that many patients. I remember attending the virtual assets training where they seem to have explained it, but due to time, I did not delve into it because it was quite a long discussion. But safe to say, there is mechanisms and we do have provisions in our law, even in our Personal Crime Act, which defines and includes cryptocurrency. The issue is the expertise. So another area of the law which we need to be discussing, and like the DP has said, is a question which has opened up our mind. Probably this should be a discussion which we should be having more in the different forums going forward. It was indeed a burning question and has left us with more questions than answers, I believe. But on that note, we will ask the